Chapter 12, Trials and Turmoil, Self-Representation and Verdict. The trial phase of this story reads like a legal thriller with a tragic punchline. By the spring of 1994, Tony Carruthers and James Montgomery were behind bars in Memphis. Police arrested them just weeks after Marcello's Cello Anderson, his mother Deloise, and Anderson's friend Frederick Tucker went missing. Prosecutors quickly charged both men with 3 counts of first-degree murder, plus aggravated kidnapping and robbery. In other words, the state accused them of kidnapping the 3 victims, robbing them of their cash and jewelry, and then killing them. For the next 2 years, court hearings, motions, and a media gag order churned through the Shelby County Criminal Court while friends and family waited for justice. From the start, Carruthers made waves. He insisted on firing attorneys, blaming them for delays and conspiracies. His family initially retained a private attorney, but that lawyer withdrew because of a conflict of interest. On May 31, 1994, the court appointed Larry Nance to represent him, and the state filed notice that it would seek the death penalty. Over the next 18 months, Carruthers cycled through a rotating cast of court-appointed lawyers. Each time, he clashed with them. He complained they weren't meeting with him often enough, and they complained that he threatened them or refused to cooperate. One attorney testified that he and his staff received threatening phone calls and letters. His secretary had nightmares about Carruthers and burst into tears after a call. At hearings, the judge patiently explained that these lawyers were outstanding, and told Carruthers that his case would not be rushed just because he demanded instant action. Nonetheless, Carruthers sent inflammatory letters accusing his lawyers of being on drugs and lying to him. By late 1995, the judge had reached his limit. He knew the case had to move forward. It had already been rescheduled 3 times. At a pre-trial hearing in January 1996, he told Carruthers flatly that he had 2 choices: work with his current attorneys or represent himself. If Carruthers chose to go pro se, the judge said, he would still require the lawyers to remain as standby or elbow counsel so Carruthers could ask them questions during breaks. Carruthers glared at his attorney, gritted his teeth, and accused him of drug use. He refused to cooperate. In the judge's view, Carruthers had sabotaged his own representation by threatening and harassing his attorneys. "You are the author of your own predicament," the judge told him. Resetting the trial again would just allow him to run off more lawyers, so the judge made the extraordinary decision: Carruthers would represent himself. The court would provide him with the rules of evidence and procedure, but he would have to conduct voir dire, cross-examine witnesses and make arguments on his own. On April 15, 1996, the trial finally began. For a capital case, it moved quickly. The prosecution presented evidence that the defendants kidnapped Anderson, Tucker, and Deloise, robbed them of cash and jewelry, drove them to Mississippi and then buried them alive after shooting the men. Carruthers, acting as his own counsel, took part in jury selection, cross-examined witnesses and delivered an opening statement. His performance did not inspire confidence. One key witness, Alfred Shaw, had told reporters before the trial that he had fabricated his grand jury testimony. Prosecutors therefore decided not to call him. Carruthers called him anyway and, in a bumbling cross-examination, managed to elicit the very damaging testimony he hoped to avoid. As one later filing put it, his questioning seemed designed to secure not only a guilty verdict, but a death sentence. After 10 days of testimony, the jury began deliberations. On Friday, April 26, 1996, the jury returned its verdict. It convicted both Tony Carruthers and James Montgomery of 3 counts of first-degree murder, especially aggravated kidnapping and especially aggravated robbery. The same jury then considered aggravating and mitigating factors and sentenced each defendant to death for each of the 3 murders. In addition to the death sentences, the trial court imposed consecutive 40-year sentences on the kidnapping and robbery counts. Carruthers' decision to represent himself may have sealed his fate. There was no forensic evidence linking him directly to the killings, yet his chaotic defense undermined any lingering doubts. The drama did not end with the verdict. Both men appealed. In 2000, the Tennessee Supreme Court reviewed the case and affirmed Carruthers' convictions and death sentences. However, the court held that James Montgomery should have been tried separately. Because he was forced to sit beside a pro se co-defendant whose antics likely prejudiced the jury, Montgomery did not receive a fair trial. The court therefore reversed Montgomery's convictions and sentences and ordered a new trial. That decision effectively removed Montgomery from death row and eventually allowed him to plead guilty to reduced charges of second-degree murder years later. Carruthers, meanwhile, remained on death row, arguing in appeals and post-conviction petitions that he was mentally incompetent and had been forced into self-representation. The trial chapter of this saga illustrates how mistrust and manipulation can doom a defense. Carruthers believed he could outsmart the system by cycling through lawyers. In doing so he lost the very thing that might have saved him, skilled counsel. The judge's unusual decision to require self-representation underscores the court's patience and eventual resolve to prevent the proceedings from being hijacked. James Montgomery paid for this drama with his own life until the Supreme Court rescued him. For Carruthers, the 1996 verdict marked the beginning of a decades-long legal battle that continues today. The next chapters will explore those appeals and the fallout that still reverberates through Memphis. Chapter 13, Appeals, DNA Petitions and Mental Health Claims. The story doesn't end with the 1996 verdict. After the jury pronounced Tony Carruthers and James Montgomery guilty of 3 counts of murder, aggravated kidnapping and robbery, the wheels of justice kept turning. Legal appeals, bizarre court filings and arguments over DNA evidence and mental health would keep the case alive for decades. This chapter looks at the winding road through the courts and the experts who later questioned Carruthers' sanity. In December 2000 the Tennessee Supreme Court issued a split ruling. The justices upheld Tony Carruthers' conviction and all 3 death sentences but ruled that co-defendant James Montgomery's case had been unfair. Because Carruthers had insisted on representing himself and routinely disrupted proceedings, the court said Montgomery's right to a fair trial had been compromised. Montgomery was granted a new trial, while Carruthers' fate remained unchanged. As one justice noted, Carruthers' antics in court virtually destroyed the decorum of the trial and made it impossible for Montgomery to defend himself. For Carruthers, the message was clear: the state still intended to execute him. Unwilling to accept defeat, Carruthers filed a post-conviction petition in 2001. He claimed his pre-trial lawyers failed to investigate the case properly and should have hired DNA experts. He accused appellate counsel of incompetence and argued prosecutors suppressed evidence. One of the main issues was a blood-stained white blanket recovered from the crime scene. Later DNA testing showed the blood did not match any of the victims or defendants. Carruthers argued this was exculpatory, but the courts disagreed. The Tennessee Court of Criminal Appeals held that the blood was minimally helpful because it didn't identify anyone else. The court also pointed out that Carruthers represented himself for most of the trial and had repeatedly sabotaged his own defense. As a result, the judges said he couldn't show prejudice from ineffective counsel because he had effectively fired them. The Tennessee Supreme Court denied his petition. Carruthers didn't stop there. He alleged prosecutorial misconduct, saying the state failed to disclose evidence and made improper arguments. He filed for DNA testing of other items, hoping to prove someone else committed the murders. But each time the courts ruled the claims lacked merit. When he asked for new DNA tests, the appellate court found the potential results wouldn't prove his innocence. In other words, even if the blanket belonged to another person, there was still overwhelming evidence that he orchestrated the kidnapping and burial of Anderson, Tucker and Deloise. Carruthers also argued that his trial was unfair because of the infamous letters he wrote from jail. In those letters, he bragged that he had a master plan to make the streets pay him and promised his future actions would be well organized and extremely violent. He even told fellow inmate Charles Ray Smith that burying a body was a good way to hide a murder because, if you ain't got no body, you don't have a case. Carruthers claimed the letters were taken out of context. But the appellate court noted that he freely handed the letters to other inmates and couldn't complain when they were used against him. After exhausting state remedies, Carruthers turned to the federal courts. In his federal habeas petition, he argued that his Sixth Amendment right to counsel had been violated. He pointed out that the trial judge forced him to represent himself after he threatened and abused a series of lawyers. The Tennessee Supreme Court had held that his extreme conduct amounted to a waiver or forfeiture of the right to counsel, meaning he had no one but himself to blame. The Sixth Circuit Court of Appeals was sympathetic but ultimately agreed with the state courts. Although the judges said they were troubled by the situation, they concluded that under federal law they had to defer to the Tennessee Supreme Court's interpretation. In essence, the federal judges said the state's decision wasn't contrary to U.S. Supreme Court precedent. Carruthers filed a petition for certiorari with the U.S. Supreme Court, but the court declined to review his case, leaving his convictions intact. As the legal battles continued, Carruthers' lawyers shifted tactics. They argued that he was mentally ill and therefore not competent to stand trial, represent himself or be executed. In 2019 the federal public defender submitted expert reports describing Carruthers' deteriorating mental state. Neuropsychologist Dr. Pamela Aubel found that he suffered from a severe mental illness which distorted his appreciation of reality and impaired his ability to understand the consequences of his actions. She suspected brain damage and believed that proper medication might have helped him control his behavior. Psychiatrist Dr. William Kenner went further, concluding that Carruthers had never been competent to stand trial or represent himself. Neurologist Dr. Ruben Gur used imaging studies and discovered significant brain damage, particularly in the right parietal lobe. Forensic psychiatrist Dr. Sean Agarkar agreed, stating that Carruthers' delusional psychosis and organic brain impairment left him unable to understand legal proceedings or assist in his defense. These reports portrayed a man plagued by hallucinations, paranoia and erratic moods. Dr. Agarkar noted that Carruthers believed the court system was part of a grand conspiracy against him and that he received secret messages through television shows. Dr. Aubel pointed out that his explosive outbursts and refusal to cooperate were classic symptoms of untreated mental illness, not deliberate attempts to manipulate the court. Taken together, the experts argued that Carruthers was never truly able to understand the charges against him, let alone represent himself. The state responded that Carruthers had been thoroughly evaluated before trial and found competent, and that his behavior was a deliberate strategy to delay proceedings. Prosecutors noted that he could write coherent letters and cross-examine witnesses when it suited him, suggesting he understood the process. They also observed that some mental health tests were conducted decades after the crime, raising questions about their relevance. Carruthers repeatedly filed petitions under Tennessee's DNA Analysis Act seeking tests on physical evidence. He argued that if the blood on the white blanket and other items could be matched to someone else, it would prove he didn't commit the murders. However, Tennessee courts consistently denied these requests. They reasoned that the evidence either had already been tested or would not, in light of the overwhelming trial evidence, change the outcome. Each denial was affirmed on appeal, and the Tennessee Supreme Court declined to revisit the issue. By the early 2020s Tony Carruthers had run through virtually every state and federal appeal available. The courts consistently concluded that his convictions and sentences were legally sound. They rejected claims of ineffective counsel, prosecutorial misconduct and flawed DNA evidence, noting that his own decision to represent himself caused many of the problems. Mental health experts painted a disturbing picture of a man with brain damage and psychotic disorders, but the courts had not yet declared him incompetent. With his avenues for relief shrinking, Carruthers was left to await the next chapter, a competency hearing and a new execution date. In the next chapter we will look at Carruthers' current status on death row, the court's most recent orders and the fate of his co-defendant James Montgomery. The long journey through the courts is far from over, and the question remains, will Tony Carruthers ever be executed, or will mental health claims and new evidence postpone his date with the executioner yet again? Chapter 14, Current Status, Death Row and Competency Hearings. It's now the mid-2020s, and Tony Carruthers sits in a tiny cell at Riverbend Maximum Security Institution in Nashville. Decades have passed since the night 3 people were buried under a casket. Appeals have come and gone, lawyers have been appointed and fired, and co-defendants have moved on. Yet the central questions, will Carruthers be executed? And is he mentally fit to face that fate, remain unanswered. In this chapter we bring the story up to date. Life on death row. Carruthers has been housed on Tennessee's death row for more than 25 years. After his conviction, the state moved a sentencing hearing to Riverbend, noting that both he and James Montgomery were already incarcerated there. Riverbend is a high-security facility where the state carries out executions by lethal injection or electrocution. Inmates spend most of their time in segregation, with limited contact with other prisoners. Carruthers' 3 death sentences mean he has no chance of parole. He will either be executed or die in prison. Despite his long stay, Tony has not been a model prisoner. Reports describe frequent disciplinary right UPS and clashes with staff. He continues to file lawsuits and motions challenging everything from his diet to the prison's mail policies. In interviews he rails against the judicial system, insisting he was framed and that hidden forces are behind his conviction. Guards at Riverbend know him as one of their most combative inmates. Some even joke that he has outlasted several wardens. A new execution date. For years Carruthers' execution was postponed due to legal challenges and uncertainty over Tennessee's lethal injection protocol. In September 2025 the Tennessee Supreme Court finally put an end to the delays. The justices denied his request for commutation and set May 21, 2026 as the date when the warden of Riverbend would carry out the sentence. The order made clear that no legal reason exists to delay this matter and directed prison officials to prepare. Carruthers thus became the first of 4 Tennessee inmates scheduled for execution in 2026, ahead of Anthony Hines, Krista Pike and Gary Sutton. As one Nashville radio host quipped, the state has set up a lethal injection calendar, and Carruthers is first in line. Competency petition and mental health concerns. The same order recognized that unresolved questions about Carruthers' mental health still loom large. Over the years, experts have described him as delusional, paranoid and brain-damaged. Dr. Pamela Auble said his mental illness distorted his sense of reality and predicted brain injury. Dr. Sean Agarkar concluded that his psychotic disorder and organic brain impairment prevented him from understanding legal proceedings. These findings prompted his attorneys to argue that he is not competent to be executed. The Tennessee Supreme Court didn't ignore those concerns. In its 2025 order it remanded the case to the Shelby County Criminal Court for a competency hearing. The justices instructed Carruthers to file his incompetency petition between February 11 and 13, 2026, so the question could be resolved before the execution date. Under Tennessee law, a person may not be executed if mental illness leaves him unable to understand why he is being punished. The trial court will therefore examine medical records, hear expert testimony and decide whether Carruthers knows the nature of his crime and the reason for his sentence. If the court finds him incompetent, the execution will be stayed until his mental condition improves. If he is deemed competent, the state will proceed on the scheduled date. Either way, this hearing represents one of Carruthers' last chances to avoid execution. His lawyers plan to present new evaluations showing brain damage, post-traumatic stress disorder and delusional thought patterns. The prosecution will counter with evidence from earlier evaluations, noting that he has been deemed competent in the past and that his disruptive behavior might be strategic rather than symptomatic. What about James Montgomery? The story of the Montgomery brothers took a very different turn. After the Tennessee Supreme Court granted him a new trial, James Montgomery eventually struck a plea deal. In exchange for pleading guilty to 3 counts of second-degree murder, he received a 27-year sentence. Because he had already spent more than 2 decades behind bars awaiting trial and appeal, he was released in 2015 with no parole supervision. His brother Jonathan, Lulu, Montgomery died by suicide in jail in 1995, so he never faced trial. James Montgomery's release angered the victims' families, who assumed both men would remain in prison for life. Prosecutors defended the plea bargain, explaining that key witnesses had died and that a retrial after 2 decades would be difficult. The plea at least secured a conviction and acknowledged his role in the crime. After his release, Montgomery reportedly moved out of state and has kept a low profile. Carruthers, however, continues to blame him and claims that Montgomery cut a deal to testify against him in secret hearings, accusations Montgomery denies. Public reaction and activism. The scheduling of Carruthers' execution revived debate over the death penalty in Tennessee. Advocacy groups pointed out that he would be the first person executed after representing himself at trial, a precedent they find troubling. They also argue that executing someone with documented brain damage and severe mental illness would violate the Constitution. An online petition urging Governor Bill Lee to commute Carruthers' sentence has collected thousands of signatures. The governor has not commented on the case, but he has halted other executions to review lethal injection procedures. On the other side, relatives of Marcellos, Cello Anderson, Deloise Anderson and Frederick Tucker say they are ready for closure. In interviews they express frustration that the case has dragged on for 3 decades. They recall how the victims were kidnapped, tormented and buried alive, and they believe the death penalty is the only fitting punishment. "We've been waiting since 1996, one family member told a Memphis reporter. It's time for justice. What happens next?" As the execution date approaches, all eyes will be on the competency hearing. The trial judge must decide whether Tony Carruthers grasps the reality of his situation or whether his delusions make execution unconstitutional. If deemed competent, the warden of Riverbend will escort him to the execution chamber on May 21, 2026, and administer a lethal dose of drugs. If the court finds him incompetent, the process will be postponed until he is restored to competency, which could mean years of treatment or indefinite delay. Regardless of the outcome, Carruthers' case has already changed Tennessee law. It stands as a cautionary tale about defendants who abuse the right to counsel and the consequences of self-representation. It also underscores the complexities of executing mentally ill prisoners. For now, the clock is ticking, and Tony Carruthers remains in his cell at Riverbend, waiting for a hearing that will determine whether he lives or dies. In the next chapter we will look at the aftermath of the trial and how the crimes affected the families and the community. We will explore the broader themes of betrayal and greed, and consider the lasting impact of burying 3 people alive under a grave.